The facts of this case are, A group of men were involved in sadomasochistic activities with each other, of whom some were sadists, some masochists. The latter consented to having some pretty violent stuff happening to them, which, you're free to research that in your own time if you wish. I'm just not going to discuss those things here. The sadists, who had committed the violent acts, were convicted of assault occasioning actual bodily harm under the Section 47 OAPA offence, that's Offences Against a Person Act, as well as the Section 20 wounding offence under the same statute. The sadists appealed their convictions, arguing that they should be overturned since the masochist had consented to the violent acts being inflicted upon them. The majority in the House of Lords rejected the appeal. Lord Templeman stated that, in general, consent is no defence in cases where either actual bodily harm, wounding, or GBH have been inflicted. In other words, consent can't generally serve as a defence to the OAPA offences. However, there is an exception to this rule where the violent act occurs within the framework of a quote-unquote lawful activity. Lawful activities include surgery, boxing, tattooing, and ear piercing, among other things. Lord Templeman went on to say that sadomasochistic activity should not be added to this list of exceptional activities, as it wouldn't be in the public interest. This is because, and I quote, "Pleasure derived from the infliction of pain is an evil thing. Cruelty is uncivilized." In a dissenting judgment, Lord Mustell stated that these are questions of private morality, that the standards by which they fall to be judged are not those of the criminal law. This case is a rather controversial one. On the one hand, it's been criticised as not respecting the autonomy of consenting participants in this form of sexual activity. On the other hand, it can be argued that there's a legitimate public interest in stopping consent being a defence in this context. Firstly, unlike activities such as surgery and boxing, the potential for harm isn't outweighed by the benefits of the activity. For example, boxing is highly regulated, it generates economic activity, and then surgery, it's necessary for public health. Secondly, it prevents the excuse of rough sex being used as a defence. Allowing this defence to be used could allow many defendants to escape liability for violence that wasn't consented to by the victim, as the prosecution may struggle to prove beyond reasonable doubt that the victim did not consent to the violence. So there's an issue with, the burden of proof.
For more on this case, please visit the link in the description, which will take you to our website. You'll also be able to find more case summaries there.